All right, it's 1 o'clock. Can we, great. My name is Monica Schmucker. I am the special magistrate that has been appointed to hear today's code enforcement hearings as provided for in Chapter 2, Article 5 of the Fort Myers Beach Land Development Code, and Florida to serve as the appointed special magistrate here today. This is a quasi-judicial hearing, which means that it's similar to a case that you will see in court, only the rules are a little bit less formal. My role here today is to fairly and objectively review today's cases and apply the agenda. In all cases, the town has the burden of proof and will present the case first. The alleged violator will then have the opportunity to speak, present evidence, and refute the town's allegations, and all parties who are here to speak on a case will have the opportunity to do so at the conclusion of each law. At this time, I would like to ask everybody who is going to provide testimony to please stand up and raise your right hand so that you may be sworn in.
I've had an attorney here.
We'll wait until your case is heard. So, all right, the town, you call the first.
Testimony and documentation regarding the case. We bring before you the FMB Code Enforcement case numbers CE 18-07 months after filing pursuant to sections 2-427 paragraph C of the Code of Ordinances for the town of Fort Myers Beach, Florida, in section 162.09 paragraph 3. Florida is the subject of this code enforcement cases by virtue of that certain warranty deed dated the 12th day of August 2013. Lee County tax collector's records also show the finish of is mixed residential. Moreover, there is no evidence that the subject property is eligible for a homestead exemption in the Lee County tax collector's records.
Printed on the internet, is available when the agenda was published.
Would you like to come forward? I take it you are the respondent? Okay, would you like to have a seat right over here? Uh-huh. There you go. Is there anybody else here with you?
No.
Now, a violation for remodeling without a permit and order compliance within 30 days with a fine within the amount of $250 to accrue for each day the violation remained in effect. Compliance was not achieved by March 1st. More than 3 months have passed since the lien was recorded on October 7th, 2020. In CE 18-0724 on January 30th, 2020, compliance was not achieved by March 1st, 2020. On October 7th, 2020, a copy of the order was recorded by virtue of recording that became a lien on the real property. Exhibit B2 is a property owner had rentals for less than 1 week, and his own were rentals were to be a minimum of 7 days, and ordered immediate compliance due to it being a repeat violation with a fine of the amount of $6,000 for the 12 repeat violations, and by virtue of recording that became a lien on the real property. Exhibit B3 is a certified copy of the recorded lien. More than 3 months have passed since the lien was recorded on June 2nd, 2021. For proceeding, if more than 3 months have passed since the recording of the lien. A copy of these authorities is marked as Exhibit C as in the agenda packet. Notice of today's hearing, January 30th, 2024. I mailed a copy of the notice of hearing by certified mail, return receipt requested, and by priority mail express to the address in the Lee County tax collector's records. A copy of the priority mail express receipt was not received, but per tracking with the U.S. not received. A notice of hearing was mailed by first class mail, posted on the subject property and the town hall more than 10 days prior to the hearing.
Okay, that's it?
Finished.
Okay, thank you. All right, you can have a seat. If you would like to respond, yeah.
Yes. August of 2022, I hired an attorney because they this
Excuse
process.
me, ma'am, can you state your name for the record, please?
Dania Carvalho.
Thank you. Could you speak up just a little bit?
Dania Carvalho.
Okay.
So the summer of 2022, August of 2022, I hired an attorney for this same process. They already did this. So my attorneys are working with town's attorneys for over a year and a half now. So this to them and myself was kind of a surprise that this is happening again on the same cases. I didn't bring an attorney because we figured this would be clear, not the proceeding, but that it's being done again, the same case. This already happened for the same numbers, so they've been going back and forth. And I've been working with an attorney, and the attorney has been working with the town attorney. So it's a little bit, we just filed, they gave us an extension this week for the 3 cases to be heard for the lien reductions, which they had agreed to last year. And we've been doing this now for some time, working back and forth with them. So this was just kind of a surprise that it's happening all over again on the same cases that we've been already, we're already so far along with. So I would like either to do this with my attorney if it's happening again separately, because I'm a little bit confused with the process.
Sure.
But yeah, that's where we're at. We're like in a whole nother place with the town's attorneys and my attorneys. And then we got this past, it was another hearing, then they changed it to this like amendment. And so I'm here, but it doesn't apply to what, it just doesn't make sense to me or my attorney.
Okay.
So I got to request this meeting. I guess we're gonna do it for a second round, I guess, with an attorney present.
Okay.
And maybe have the attorneys reach out to the attorneys that we're working with, I guess, so that they can communicate. But something might have been lost in transitions here.
Do you care to question her?
So I can clarify.
Sure.
On behalf of the town, I'm Nancy Stuperidge, I'm with the Vos Law Firm. What Ms. Ortiz is referring to are some separate proceedings that are ongoing. She has filed a request to have the amount of the liens reduced, which is a separate proceeding. There is a pending foreclosure case, which is a separate proceeding. What we're here before the magistrate today is to simply get an order authorizing the filing of the foreclosure. It's a very limited issue.
But I thought you had already done that. Like,
It has
2 years
not been
ago.
done, we're doing it now.
Okay. Sure. Did you notify your attorney about this proceeding?
Yes, but they were just like, we've already done this. Like, this already
Okay.
happened.
Okay. All right. Thank you. Is that all? Okay. Thank you. All right. Just for the benefit, I cannot relitigate the issues that are in these liens. This is not a repeat of the litigation of these issues, these prior liens, or these, prior fines.
The same cases. Like,
Hang on. So the magistrate orders that are present, and you have them before you, these exhibits, I have the magistrate orders, those appear valid on their face. There's nothing that I see that's wrong or incorrect. They've been filed, and by virtue of having been filed, they do create liens. So that appears to be valid on its face. And the notices have been everything that they've presented, which everything here, pursuant to the statute, it says that you have to be notified of this procedure a certain way. All of those things have been checked off, right? They've been mailed. We have the photographs, we have the affidavits, all of that. And it doesn't seem like you are disputing that. This is simply a procedure that says all of these things have been done, and it authorizes the town to proceed with the next step of foreclosure, right? And so what we're doing here is, I mean, you don't dispute that these liens have been recorded, all of this is correct, you've received all of this, okay?
Yeah, we took everything up to code, we. did
Okay,
all the work.
so pursuant to section 2-427 subsection C and Florida statute 162.09 subsection 2, foreclosure may be authorized when a lien remains unpaid for 3 months or more after its filing, which that's what's happened here, provided that it's not a homestead property, which is the case here, and provided that proper notice has been served. And in this case, these liens have been remained unpaid for several years, of 2020, 2021, and everything else. So based on what I see here, I don't see any reason to not authorize that foreclosure. However, if you're working out something else, that's a separate issue. We're not foreclosing here today, right? We're authorizing the next step. So is that, would you say?
That's the town understanding.
Right. So, I mean, unless you tell me that this isn't, but I mean, you've already dealt with this and you're dealing with it. So the only thing we're doing here today is authorizing the next step to follow the proper procedures in order to foreclose. Now, if you guys resolve it before then, great. But my role here today is simply to authorize that next step to foreclose, okay? So if you have an attorney, then I suggest that you speak with your attorney, but do you disagree with anything that I just said? You received the notices, or these notices, okay, all right. Then my decision here today is only based on the evidence of record that, and what I have heard here today. When all the facts are applied to the law as it is stated here in the statutes, I see no reason why the town of Fort Myers Beach should not be authorized to pursue a foreclosure of these liens. So, do you have anything to add?
No, Your Honor. We'll get the order from you within the 15-day period. I have provided a proposed order. Please, again, if you want to change it or whatever,
Sure.
it's clearly your prerogative.
I do see the proposed order. Have you provided Ms. Carballo a copy of it?
Yes.
Okay. So, Ms. Carballo, my recommendation to you is to contact your attorney and provide them with these documents. We're not foreclosing here today, but they are proceeding. So, and I'll take a look at this order and you'll receive the final order in the mail. Okay? All right? So, hang on one second. All right. So finding that all the requirements have been met and the procedures have been followed, I will authorize the proceeding and I'll take a look at this order and the final order will be submitted. Okay, thank you. Get the town call the next case. Are you ready?
Yes.
Okay.
Next case has to do with Sands property. Second case on the agenda. My name is Bill Stout. I'm a code enforcement officer with the town of Fort Myers Beach, and I've been in this role for approximately 4 years. I've been sworn in, and I will provide testimony and documentation regarding this case. We bring before you the F&B code enforcement case numbers CE 14-0394, CE 15-0167, and CE 17-0065. This is a request for the authorization for the town attorney to propose on 3 recorded liens that have remained unpaid for a period of more than 3 months. After filing pursuant to section 2-427, paragraph C of the Code of Ordinances of the town of Fort Myers Beach, Florida, and section 162-09, paragraph 3 of Florida statutes. Subject property is located at 80 Avenue E, Fort Myers Beach, Florida, 33931. Respondent, White Sands Properties of Fort Myers Beach LLC, owns the real property that is subject of this code enforcement case by virtue of the certain deed in lien of foreclosure, which was recorded on July 20th, 2020 in official record instrument number 202000000165-414, as corrected by a corrective deed in lieu of foreclosure, which was recorded on September 24th, 2021 in official records. Invest instrument number 2021-0003-25050. The Lee County Tax Collector for those records also show respondent White Sands Properties of Fort Myers Beach LLC as the owner of the subject property. Subject property is the homestead property of the respondent. Property is currently vacant and was previously used as an investment property. It is zoned downtown zoning, and its future land use is pedestrian commercial. Moreover, there is no evidence that the subject property is eligible for a homestead exemption in the Lee County Tax Collector records. Also, we have included a copy of the permit printout from SunBiz showing that the White Sands property is a registered corporation and showing that Stephen A. Ramuni is the registered agent. I request a copy of these documents be accepted into the record for this case as Exhibit A.
We have a copy over there.
I'm going through it now.
Okay, thank you. You're going through it?
Yeah, no, I'm good with it.
Okay, all right. It's been accepted.
In CE 15-0167, on February 24, 2016, the special magistrate found a violation since the property was occupied without a permit for the replacement of the main egress to the property in order of compliance prior to March 25, 2016, with a fine in the amount of $250 to accrue each day the violation remained in effect. Compliance was not achieved by March 25th, 2016. On April 12, 2016, a copy of the order was recorded, and by virtue of the recording has become a lien on the real property. Exhibit B1 is a certified copy of the recorded lien. More than 3 months have passed since April 12, 2016. In CE 14-0394, on February 24, 2016, the special magistrate found a violation for remodeling and rebuilding stairs without a permit and order compliance prior to March 25, 2016, with a fine in the amount of $250 to accrue for each day the violation remained in effect. Compliance was not achieved by March 15, 2016. On April 12, 2016, a copy of the order was recorded, and by virtue of the recording, it has become a lien on the real property. Exhibit B2 is a certified copy of the recorded lien. More than 3 months have passed since April 12, 2016. Lastly, in case CE 17-0065, on July 26, 2017, the special magistrate found a violation for installation of pavers without a permit and ordered compliance prior to August 30, 2017, with a fine in the amount of $150 to accrue for each day the violation remained in effect. Compliance was not achieved by August 30, 2017. On July 9, 2019, a copy of the order was recorded and by virtual recording has become a lien on the real property. Exhibit B3 is a certified copy of the recorded lien. More than 3 months have passed since July 9, 2019. Section 2-427, paragraph C of the Town of Fort Myers Beach Code of Ordinances and section 162.09, paragraph 3, Florida statutes, authorize a special magistrate to authorize the local government attorney to file foreclosure proceeding if more than 3 months have passed since the recording of a lien. A copy of these authorities is marked as Exhibit C in your packet. Notice of today's hearing was provided in accordance with section 2-427 of the Town of Fort Myers Beach Code Compliance Ordinance. Copies of the notices and attached orders sent via certified mail and priority mail express to both the property owner and the registrar are marked as Exhibit D. On January 30th, 2024, I mailed a copy of the notice of hearing by certified mail, returned, received, requested, and by priority mail express to the address in the Lee County Tax Collector's records. A copy of the return receipt requested and a priority mail express receipt was not received, but per tracking United States Postal Service, the notices were delivered on January 31st, 2024, and is included in the agenda packet for the record as Exhibit E. Copy of the return receipt requested to the property owner was not received, and a notice of the hearing was mailed by first-class mail, posted on the subject property and town hall more than 10 days prior to today's hearing. The unclaimed USPS tracking for the certified mail and prior express mail is in this Exhibit E. I have prepared an affidavit regarding with compliance with section 2-4.7 of my mailing and the posting on the subject property and town hall regarding today's hearing to be included in the record as Exhibit F. Based on my sworn testimony and the evidence that has been presented to you as exhibits in the agenda packet, I request that you authorize the town attorney to foreclose the recording. We have prepared a draft order for your review. Thank you. Only one?
Yeah, there's two.
Okay.
Do you need one back?
No.
Okay,
That's it.
all right.
Thank you.
Good afternoon. For the record, Stephen Remuning, P.O. Box 1118, LaBelle, Florida, 33975. I'm the attorney for White Sand Properties and Fort Myers Beach LLC. I'm also the registered agent for the same entity. The liens in question were originally due to violations against the predecessor in title to White Sand Properties. That would be Mr. Joseph Orlandini and Absolute Best Rentals, I believe, LLC. When my client, in approximately late 2019, my client was negotiating to buy the check from, it's from Schmidt's Machinery Company, but it's the same owner. His name is Mr. Jesse Schmidt, SCHMID. He owns both Schmidt's Machinery and White Sand Properties of Fort Myers Beach LLC. I could.
Make sure you provide.
Sure, I have a copy for council.
Thank you.
As you can see, the check is dated December of 2019, I think specifically December 19th, 2020. It was cashed by the city on the next day, December 20th of 2020. So technically, we're not disputing the existence of the liens or anything having to do with how those liens came about with regards to their initial hearing, code enforcement hearing, and the recording of those liens. However, my client contends that those liens have been fully satisfied as to the properties he purchased from Mr. Orlandini pursuant to the then settlement agreement that he had with the town manager. That's really, in essence, where we're at. There, I would note, just like the prior case, there's already a foreclosure of these liens pending in circuit court here in Lee County. So looking at the town code, it looks like that foreclosure case was premature because, to my knowledge, it's never been before Your Honor previously. So now that they're moving forward, we would raise the issue that these liens should be satisfied as it pertains to the properties purchased by my client pursuant to the settlement agreement with the town back in late 2019. And as you heard, the property, this 80 Avenue E property, was purchased by my client. Actually, there was a deed in lieu of foreclosure that's from March of 2020. Shortly thereafter, there was a corrective deed that was recorded several months later, but the actual purchase happened in March of 2020. So.
Do you have any documentation at all of any of the agreements or anything?
Well,
relating?
Unfortunately, at the time he was representing himself, he met with the town manager, Mr. Herstad. Also, Mr. Orlandini did, but that's a different story. We're not speaking to any issues as it pertains to what he did or did not do as it pertained to the town of Fort Myers Beach. However, as you can see, there was $50,000 paid to the city for this particular issue, so we would contend that the check and the endorsement of the check by the town, and you'll see partial release for 1560I. There were two properties that were purchased from Mr. Orlandini, was that property and the 80 Avenue East property. about the same time frame. So there was no lien as it pertained to the 1560. It was all related back to the 80 Avenue East lien, or the 3 liens rather, on 80 Avenue East. So we would contend those liens have been fully satisfied.
Okay, thank you.
Thank you.
Sure. Response?
Your Honor, what is being presented to you as evidence is a photocopy of a check. We don't have any backup information to know the validity of the actual copy that is being provided to you. It has been 5 years since the date of this check, and if I were providing a check for $50,000 to someone in anticipation of a release or a partial release or a satisfaction, I would have surely made sure that I had the necessary document recorded in the public record for $50,000. Also, I would note that if it was, and I'm not disputing, I'm just raising the fact that there is a current pending foreclosure case, and I do not believe that the prior town attorney would have moved forward if there was documentation on the town side that the lien had actually been released or partially released or completely satisfied.
My response would be, since there are questions then as to legitimacy of the check, which Your Honor stated the rules of formal evidence are not being heard today, but if that's the case and we need to go put our finger back on a certified copy of the check or the check itself, we can certainly go do that. If we need to investigate whether or not the town was authorized to seek its first foreclosure, we can do that. So I would perhaps suggest we continue this for 60 days to look into these particular issues, because as you can see, that's substantial evidence of some settlement, and we would contend that not only is the current foreclosure perhaps not lawfully brought, but that a second foreclosure should not be brought because of the settlement. And these are legitimate questions, so it's not any type of delay tactic, because my client, as you can see, did what he did back in 2019. In a perfect world, sure, as if I was representing him at that point in time, I would have certainly had a little bit better paper trail to show that those 3 liens had been released, and that was, the essence of the agreement. But unfortunately, he did it himself. But there's, I believe, evidence before Your Honor that at least calls into question whether or not these 3 liens currently are legitimate. Thank you.
Just a very quick response. We really, there is, as has been mentioned, a pending foreclosure case on this matter, and there is the opportunity to raise the arguments that counsel is raising in that proceeding. I understand, too, that there was an attempt for a settlement in that case, but I don't want to dwell into the foreclosure case because we are not here to argue about the foreclosure case. We are here to argue that there is a recorded lien of record. It has been of record for more than 3 months, and the statute authorizes to file a foreclosure case. Proper notice has been had. The party is represented by their attorney today and has presented argument.
If they still remain as legitimate liens, and that's the question.
Okay, thank you. Okay. Anything else?
No, thank you,
Okay,
Your Honor.
sure. Okay, so again, I'm not here to relitigate the issues, the liens and the underlying facts of these liens. The orders themselves appear valid on the face, and they were recorded, and they were recorded many years ago. I do appreciate this check that you've provided, but I do see that a few things, it says partial release, and it also has a different address, and I don't have any documentation to be able to say that this is sufficient evidence to call into question anything that I have before me. As far as what is on the record, the notice has been proper, and liens have not been paid since, well, it looks like 2016 when they have been recorded, notwithstanding this copy of this check. And I agree, it's just a photocopy of the check. I don't even know what it's for. So seeing that this is not a homestead property, that proper notice has been given under section 2-429, which outlines the way to provide proper notice, and finding that all the requirements for foreclosure have been met, the procedures have been followed. I see no reason to deny the request to authorize the town to initiate the proceedings to foreclose the liens. However, I will say, all of the claims and defenses will be available to you in those proceedings, and that is the appropriate place to bring this up. This is not enough evidence to say that the liens are not valid on their face. So the relief being requested, simply to proceed.
The authorization is
Okay, I will take a look at this, this order.
I might have some objections to it, it was just handed to me.
Okay,
so
do
if
you
I
have,
can
absolutely, you can take a few moments or however long you need to review it and let me know if you have any objections to it. I have not accepted this yet as the actual order, but,
Like, for instance, in number 2, my client was not found in violation of the code. Number 3, my client did not fail to comply.
Your Honor, we have no objection to clarifying that if they want to state into the order that his client was a subsequent purchaser, successor in interest.
okay.
B2, we would, obviously, Your Honor's ruling would speak for itself, but we believe that we have shown legal reason why there shouldn't be foreclosure. Those would be my objections at this point.
Do you want to submit a competing order?
Sure, I can.
Okay,
Your Honor, we would just state in response to B2 that there has not been a showing of competent substantial evidence to show that that foreclosure should not be appropriate at this time, or the collection of the fine.
okay.
So is your,
So,
my question would be on the substantial competent question, evidence question, or is Your Honor questioning whether or not the copy of the check itself is not adequate, or for other reasons?
no. And I'll issue findings and fact, but I will tell you that I'm not questioning whether this is a valid check or not. It may be, it may not be, but that is not the reason for. My finding is that this is not sufficient evidence to refute the validity of these liens. This is a check for $50,000 to the town. It says partial release. It doesn't say anything about it being a full release. It says a different address on here. I don't doubt that they're not related, but I can't make those guesses. The evidence before me is quite clear as to the properties that are involved, the liens that were recorded, and the fact that they have not been paid. This is not proof that they have been. I don't see a release of lien. I don't see an agreement. I don't see anything to be able to refute the validity of these documents. That's what I'm saying. Now, that doesn't mean that those defenses are not available to you in the foreclosure proceedings, but this is a proceeding to simply authorize, based on the evidence that has been brought before me, the initiation of foreclosure proceedings, and that is where my decision, that's what my decision is. It's simply just whether they can proceed.
But if you just want to, indicate in those paragraphs who the proper respondent is, that probably would suffice, but I don't know if council wants to try to draft something you want me to submit. I mean, it would be minor in the sense of the changes from this form order, so, but I'll do whatever Your Honor directs me to do.
So what I'll do, if you would like, you can, if you would like to prepare an updated order, or.
Your Honor, I think it might facilitate if opposing counsel, if they make whatever changes they want and we can react to them, just to keep this item moving along,
Okay.
and hopefully it can get resolved at some point in the future.
I can do that, and I can send it to, can I have your card for the form? Or how would you like that done?
Do you want it to go through you, or do you want us to work it out? and
You,
send
I
it?
mean, you're more than welcome to work it out and send something to me that's agreed. If it's not agreed or you can't come to an agreement, you can send to me opposing orders. I would ask that you do that within a week of today, and I may or may not make any changes or additions thereto. Okay?
I believe that just for everyone's information, the clerk will have a copy, a Word version of the document, and if you can send that to him, that might make it easier to strike and insert.
Appreciate it. Thank you.
Okay, thank you. All right, thank you. The next,
Magistrate, the next case is for 1661 Estero Boulevard, Fort Myers Beach, Florida. It's Key Estero Shops LLC. My name is Bill Stout. I'm a code enforcement with the town of Fort Myers Beach. I served in this role for approximately 4 years. I've been sworn in, and I will provide testimony and documentation regarding this case. We bring before you FMB Code Enforcement Case Number CE 19-0026. This is a request for authorization for the town attorney to foreclose on a recorded lien that has remained unpaid for a period of 3 months or more. After filing pursuant to Section 2-427, Paragraph C of the Code of Ordinance of the Town of Fort Myers Beach, Florida, and Section 162.09, Paragraph 3, Florida statute. Subject property is located at 1661 Estero Boulevard, Fort Myers Beach, Florida, 33931. Defendant, Key Estero Shop LLC, owns real property that is subject of this code enforcement case by virtue of that certain warranty deed dated first day of March 2017. The Lee County Tax Collector records also show defendant Key Estero Shop LLC as the owner of subject property. Subject property is not the homestead property of the respondent. The current use of the property is for commercial shops. It is zoned downtown zoning district, and its future land use is pedestrian commercial. Moreover, there is no evidence that the subject property is eligible for a homestead exemption from the Lee County Tax Collector's record. Also, we have included a copy of the printout from the Michigan Department of Licensing and Regulatory Affairs showing that Key Estero Shops LLC is a registered corporation and showing that Laura Macarata is a registered agent. I request a copy of these documents be accepted in the record for this case as Exhibit A. On January 20th, 2020, the Special Magistrate found a violation that the property was operating in a legal parking lot and ordered compliance within 30 days with a fine in the amount of $200 to accrue for each day this violation remained in effect. Compliance was not achieved by March 1st, 2020. On September 11th, 2020, a copy of the order was recorded by virtue of recording as became a lien on the real property. Exhibit B is a certified copy of the recorded lien. More than 3 months have passed since September 11th, 2020. Section 2-427, Paragraph C of the Town of Fort Myers Beach Code of Ordinances and Section 162.09, Paragraph 3, Florida statutes, authorize a special magistrate to authorize the local government attorney to file such a proceeding if more than 3 months have passed since the recording of a lien. A copy of these authorities is marked as Exhibit C in your packet. Notice of today's hearing was provided in accordance with Section 2-427 of the Town of Fort Myers Beach Code of Ordinances. A copy of the notice is attached as Exhibit D in the agenda packet. On January 30th, 2024, I mailed a copy of the notice of hearing by certified mail, return receipt requested, and by priority mail express to the address of the Lee County Tax Collector's record and the agent registered with the Michigan Department of Licensing and Regulatory Affairs. A copy of the priority express mail receipt was not received, but per USPS tracking, notice was delivered to both the owner and the registered agent on January 31st, 2024, and it is included in the agenda packet for the record as Exhibit E. A copy of the return receipt requested was not received, and the notice of the hearing was mailed by first class and was posted on the subject property and town hall more than 10 days prior to today's hearing. I have prepared an affidavit regarding compliance with section 2-427 of my mailing and posting of the subject property in town hall regarding today's hearing to be included in the record as Exhibit F. Based on my sworn testimony and the evidence that is presented to you as exhibits in the agenda packet, I request that you authorize the town attorney to foreclose on recorded. Thank you very much.
Thank you.
I have for you. Thank you.
Thank you.
Hi, how you doing? I'm Carmelo Nacarado, Rhoda's father.
Could you state your name again?
Carmelo Nacarado.
Okay.
Yeah, I'm Laura Nacarado's father. So you would have been to start from the beginning?
Well, do you have a response to what?
Oh, ma'am, I'm 78 years old. I cannot hear too good at all.
Okay. Do you have a response? They've brought.
I couldn't even, I didn't hear anything he said. And the only thing I can tell you, the history, you know, what about the property? We bought the property March 1st, 2017. I went to the town hall. I invested the property over here at the beach since 2002. So I know, you know, the people at the town hall and the mayor and everybody, so we bought the property there. They want to do the beach park and everything since they built the plaza. That's one reason we bought the property, because the building it was 3/4 empty. So, you know, we're gonna generate some money by parking cars. So I went to the town hall and said, we bought the property. I said, do I need any permits? What do I have to do? The mayor there, okay, the general manager, what it was, said, no, you don't need anything. So until 2018, August 11th, we never had any problem. The new administration that came in, and I forgot her name, but the mayor, okay, I forgot her name, this and that, okay.
Sir, can I just stop you for a second?
Yeah.
I appreciate that you'd like to give me the history. I have to explain to you, my role here today is simply to see whether these liens have actually been filed by virtue, I mean, the orders of the magistrate. You do agree that the orders of the magistrate have been entered before in the past, correct? You have these fines, is that correct?
Yeah.
Hang on a second. If they've been entered, they've been filed, right? Do you disagree that these orders of the magistrate have been filed? These previous?
Yeah, I had an attorney, we went in front of the magistrate. And the magistrate at the time, I don't remember, you know what year it was. The magistrate at the time, I had an attorney who represented me. His name was Steve from Babesi firm. Right in front of my attorney, the administrator there, she said, she was from Miami. She said, Carmen, just like that. She says, get a use permit in 30 days. Okay, I went into the town there, okay, the second day to apply for permit. Okay, this is Jason Green. He said, Carmen, you gotta, before we issue you a permit, you gotta do a lot of improvements to the landscape, to this and to that. So my hands were strapped. I said, how can I get a permit? The magistrate at the time, and then made it, you know, said, you gotta get a permit. You do, and then say, you gotta do this, you gotta do that. Because I had done all of that. I invested $70,000 to redo the landscape and everything. I improved the plaza. I invested another $800,000 or $900,000. They just refused to give me my permit. And that person, like I said, if you look on Google, okay, there are 5 parking lots on Google, and one is,
Sir,
you know,
sir,
public parking.
Sir, can I just stop you for?
We are included.
Sir, can I just stop you for?
They just want to destroy it.
Excuse me. I understand what you're saying.
Yeah.
I cannot rehear those cases right now. That is not what I can do, okay? So I appreciate the history that you're providing, but I can't rehear those cases. There are orders that were entered, and those orders were filed, and by virtue of having been filed, they were liens on your property. Now, if those liens have not been paid within 3 months, then the town can be given the authority to proceed with foreclosing. And the evidence that I have before me is that those have been filed, and they became liens in 2020. And unless I have some sort of evidence that you can provide me that these liens have been satisfied or released or something else to invalidate this, I can't rehear those cases. However, if they proceed with the foreclosure, you have every right to bring the defenses that are available to you, but I can't hear those here today. I can't hear those.
I understand, but like I said, we had a mediation. We had a mediation, court mediation. There was about maybe a month ago.
Okay,
Okay, but we wanted to settle. The mayor, he was stuck on $250 million.
okay.
He was stuck on $250 million.
I understand, but I cannot hear that issue here today.
Like I said, I'm shocked that we are here. I was.
Okay.
I'm a business.
Sir, have you paid the liens that were here?
Pardon?
You've not paid, you are not telling me that you paid these liens, right? You said you've mediated them, but you've not come to any sort of anything, agreement,
The
nothing? Okay.
next step, I was expecting to go to trial in front of the judge,
Okay.
not to come in front of you, not because you know what I'm saying.
Right, well, that will be the next step. If foreclosure
Yeah, but the
is
judge-
authorized, you will then proceed to the next step.
The judge said, yeah, you owe $250 million. I'll pay. I got a problem. I do not.
Okay, all right.
Your Honor, what they did, the town of Fort Myers Beach, they tried to destroy the soul man, bury me, period. They're evil people. I'm telling you right in front of everybody over here. They're evil people. I've been in business since
Okay.
I've been in business since 1972. I came from Mill. I was 19 years old at age of 25. I started in business in Michigan, and I'm in 2 states, and I'm done here. I still work 70 days a week. This and that, okay?
Okay.
And you know the reputation that Fort Myers Beach has. I don't know why.
Okay.
Why? You know, I'm here. I really don't.
I'm sorry, sir.
You know what I mean?
I'm sorry, I can't rehear those cases though, so
No,
unless,
that's it. I'm here.
okay,
If
thank
the
you.
judge- If the judge, I'm gonna go to court.
Okay.
What the judge says, I'll do.
Okay, thank you.
So my
Do you-
daughter said, she said, make sure that they're not going, because we know they're crooked people. You know what I mean? I don't have to tell you.
Okay.
Everybody,
Sir-
I'm not telling you that you know, or the attorney, but the administration, it goes from one administration to another.
Right.
Corrupted.
Okay.
It's a disaster.
Okay, sir, my
And like I said,
recommendation,
my daughter, she said,
Okay.
we need to go in front of the judge.
Thank you.
Whatever the judge says, if he says, hey.
okay, all right, we're done.
The second day,
Thank
I'm
you.
gonna deliver $250 check.
Okay, thank you. You may have a seat. You can sit right there.
Okay.
Thank you.
so much.
Mhm.
Okay, I'm sorry. Okay.
That's okay, please have a seat right there. Thank you.
Like I said, you know, I think what he made, exactly what he read, I could, you know,
That's-
respond to that.
Sorry, thank you.
Your Honor, may I just
Do you have
add
any
to
res-
the record? So when these prior orders are challenged, any order that's issued by the magistrate, there is an appeal period of 30 days.
Right.
So that was a process that was available to him and his attorney way back when the initial orders were issued. And yes, there is a pending foreclosure case right now, which we are hoping with the authorization from Your Honor that we can move forward with. There will be opportunities for discussion if there's possible settlement. I believe there was some initial discussions regarding settling. And if not, as the gentleman suggested, we will look for the judge
Can I come a little
to
closer? I
direct
can hear
us,
you.
Hey, okay,
to direct us
Okay.
and proceed accordingly. We just would like to move this case forward and come to a conclusion.
okay, thank you.
I
So,
understand what, I
Sure.
get it.
so,
Can you guys do me a favor, put it in writing, you know? just-
yes. So please understand, I cannot rehear all of the cases that you have had before the magistrate, and I can't do that, okay? So, to me, I'm looking at these orders that have been entered, they have been filed, they have become liens, unless you have paid them or you can show me some sort of a satisfaction. I don't see that they're not valid, okay? The next step is what they're requesting, which is to proceed forward with foreclosure, okay? They will file whatever the documents that they need and follow those steps, the appropriate steps for that foreclosure. So what she was saying was there could be negotiations for settlement. That is not up to me, okay? The only thing that I have to do is take a look at the documents that were provided. The liens appear to be valid on their face. The notices all appear to be proper pursuant to law. We have it was mailed, we have the photos, the affidavit, everything has been done properly.
With everything you said.
So pursuant to section 2 dash,
You got, like I said, we're gonna
Excuse me.
get this over.
thank you.
I'm sorry.
That's okay. Pursuant to section 2-427 subsection C and Florida statute 162.092 subsection 2, foreclosure may be authorized when a lien remains unpaid for 3 or more months after its filing, provided it's not homesteaded and provided that the proper notice has been served. I find that the lien has been unpaid for several years. This property is not homesteaded. Proper notice has been given under section 2-429, which outlines the different ways that notice has to be provided, finding that all the requirements for foreclosure have been met, and you don't dispute that they've done those things, so the procedures have been followed. I don't see any reason to deny the request to authorize the town to initiate proceedings to foreclose on the liens. The actual foreclosure proceedings will be in the appropriate venue. That is not what I am deciding here today, and like I said, all of your defenses and all of the claims will be available to you, whatever is available to you. So my decision today is that based on the evidence heard here today, when all facts are applied to the law, the town of Fort Myers Beach is authorized to proceed with foreclosure of these liens. I have a proposed order. Is this? Yes. I will take a look at the proposed order. Did you see this? This is the proposed order. So what I will do is yes, it's not final, so I will take a look at this. And if I need to add anything or change anything, I will, but you'll receive it in the mail, okay? And, you can proceed, you can continue whatever negotiation. My recommendation to you, though, is that once you get this, you get in touch with whoever you need to make sure you have whatever you need to as far as defenses are concerned for the next proceedings, okay?
Yeah,
All right, you'll receive an order in the
like
mail.
I said, I got time today. If we can meet up, let's get this settled. I got all
We can talk
day.
after the hearing.
Yeah.
I think we're.
Pardon?
Okay, so we're good. So that's it. You'll receive an order in the mail, okay? And then,
Like I said, I want to get this settled.
okay, well, we have another proceeding. You guys you can call the town.
Later today.
Can I wait around?
Yeah.
Sure.
Can I wait around?
Yeah, I know.
Yeah, 5 more minutes.
Okay.
Thank you so
Your
much.
Honor, if I may, I can very quickly lay an introduction.
Yes.
The next item, the code actually does not require it to be a public hearing. We will be seeking an order acknowledging compliance. I would like our code officer to go ahead and just provide you with the factual background. And once you hear that, I believe that that should be enough to get into the
Sure.
record. We're just looking for an order of compliance.
Sure. And I did review all the documents that were submitted.
Okay.
Yeah.
Your magistrate, my name is Bill Stout. I'm a code enforcement officer with the town of Fort Myers Beach and have served in this role for approximately 4 years. I've been sworn in and will provide testimony and documentation regarding this case. This is FMB Code Enforcement Case Number CE 20-0538. We request of the special magistrate to issue an order acknowledging compliance pursuant to section 2-425, paragraph C of the Code of Ordinances of the town of Fort Myers Beach, Florida, and section 2-425 is attached as Exhibit A. On the 18th day of February 2021, Roland Wayman and Beverly Ann Milligan, property owner, was found in violation of the town of Fort Myers Beach LDC, section 34-2391. multiple weekly, daily rentals during a 1-month period at a property located at 133 Andre Marr Drive, Fort Myers Beach, Florida. Subject property, by virtue of the code enforcement order by the special magistrate in case CE 20-0538, which was adjudicated on 18th day of February 2021. The order was recorded as an instrument number 202100006897 on the 5th day of March 2021 in the public record of Lee County, Florida. The order is attached as Exhibit B. Roland Wayman and Beverly Ann Milligan were given 51 days to come into compliance with the special magistrate's order, which was on or before the 10th day of April 2021. According to available records in possession of the town of Fort Myers Beach, an inspection of the subject property was performed by a code enforcement officer on the 19th day of April 2021, and the subject property was found to be in compliance. No further action was taken by the town of Fort Myers Beach regarding this violation, which was corrected as stated above. Code enforcement case number CE 20-0538 is closed. My personal knowledge of all these facts based on my review of records in the possession of the town of Fort Myers Beach, Florida. The signed and notarized affidavit of the town is attached to Exhibit C.
So, Your Honor, we're simply looking for an order from you that can be recorded in the public record for title purposes.
Okay, all right, thank you. Yeah, I have reviewed the documents, and that's fine. I would be happy to enter in an order. Do you have any?
We don't have
Okay, that's
a
okay.
form for you, and in the future, we'll just have this as an agenda item, and
Sure.
we'll have cases that have come into compliance, so as the code says, we don't even have to have a public hearing.
Right, but it'd be good to have one that's recorded, an order that's recorded, and that way we have
Yes.
notice. Okay, that's fine. Okay, yeah, I will prepare an order showing, well, an order of compliance to be recorded, and,
And we have no further items.
okay, all right, that's it, great, thank you. Have a good afternoon.
You too.
All right, then, I guess this session is adjourned. All right, thank you.